Hi everybody, it's Richard Jefferson. I'm coming back with another topic. This one's a hot one. This one is very hot for any old school artists, producers, anyone who was creating something back in the late 70s, early 80s. This most applies to you, but it also applies to anyone who's a creative person, because it's going to change the way contracts are made going forward very soon. What I'm talking about is the author's copyright termination right. And what this is a provision of the Copyright Act that says that an author who creates content for a contracting party and transfers those rights has the right to pull those rights back and regain ownership after 35 years from the date of that contract, or maybe publication, but most likely the date of the contract. Why is this so important? Well, I think the main reason is that most contracts, when you're dealing with record labels or studios or production houses, they say that you're transferring over the life of the copyright. But if the Copyright Act is saying that you can regain those rights after 35 years, which one prevails? Well, copyright is federal law, contract law is state law, so the Copyright Act is going to prevail. You're going to be able to trump that contract by asserting your rights from the Copyright Act. Okay, so kind of in layman's terms, say you're a production house that has artists, and you license music over to a record label for distribution. And their contract says that you're giving us the rights for the life of the copyright. Well, that production house can send a notice and actually get those rights back 35 years later. That may seem like a long time, but just think about what's going on right now. The way content's being reused, old school content's popular on the internet, used in ringtones and video games and interactive games. You name it. There's just a lot of money in reusing existing content. So what this right will do is allow you to either renegotiate a better deal with the contracting party, or you take back those rights and you can do your own deals or find another contracting party. So that you can kind of see why this is could be very powerful. Some of the gray areas are like an artist. Now, is an artist considered an author of an album or of a song, or a songwriter? Is a songwriter considered an author of the song, or are they work for hire? Well, their contracts say both, because they were trying to cover both their bases back then. Look at your contract, you'll see that both languages kind of used. So there is no straightforward answer, and all this is going to be worked out in, I'm sure, in litigation and case law and settlements very soon. So these are the things that are brewing underneath. But I really think that you should know, and I really need old school artists and people to understand this, because if you created something in 1978, then 35 years later is 2013, and that's when you'd be able to get your content back. But in order to do that, you have to give notice 2 years before that date. Say you had a great hit back in 1978, you need to give notice to that record label by January 1st, 2011, that you're planning to terminate their rights to use it, and you're going to regain those rights. So, something to think about. There are obviously some details that need, a lot of details that need to be analyzed. You should talk to your attorney before you approach a label. Just don't go crazy and start writing letters. You really want to do this the proper way. Just make sure you understand whether you have this right or not. There's more information about this, a little more detail on my blog, and feel free to subscribe to it. You can reach it at www.metallawgroup.com. That's METAL lawgroup.com. And there's a lot of information on this topic, plus other things that I've talked about on my video blogs and articles that I've written. Okay, so thank you.